2024 advisory opinion, the Court indicated inter alia that a key element of the right of self-determination is a nation's right to pursue its economic, social and cultural development. In the aforementioned opinion, the Court was already using the principle of self-determination to interpret Israel's obligation as an occupying power. Thus, the existence of Palestinian people's rights to self-determination cannot be subject to conditions on the part of the occupying power, particularly in the context of delivering humanitarian and development assistance. For the Republic of Poland, it is unquestionable that through application of systemic integration, the principle of self-determination strengthens Israel's obligations under IHL. These obligations should be construed as prohibiting any arbitrary blockade on humanitarian assistance to the population of an occupied territory in need of such assistance. Any arbitrary blockade can be understood as an obstruction that is unreasonable, unjust, lacking in predictability, or otherwise inappropriate. Mr. President, members of the Court, I now turn to the issue of children's rights in the context of humanitarian assistance. In our written statement, Poland emphasized the Court's jurisprudence on the relationship between international human rights law and IHL. We have stated that in the analysis of obligation towards civilian population, human rights concerning humanitarian assistance must also be taken into account. At this stage, we would like to concentrate on children's rights, taking into account our engagement with the topic since at least 1978, when Poland presented the idea of the Convention on the Rights of the Child. In armed conflicts, the regime of protection envisaged in the Convention must be interpreted as taking into account subsequent Security Council resolution on the matter. These resolutions underline the obligation of parties to armed conflict to ensure full, safe and unhindered access of humanitarian personnel and delivery of humanitarian assistance to all affected children. Furthermore, the denial of humanitarian access by parties to armed conflict is considered by the Council as a violation of international law committed against children. Thus, Poland's view is that Israel has an unequivocal obligation to ensure access of humanitarian assistance to all children affected by armed conflict in territories that are under its effective control or besieged by Israeli forces. Mr. President, I now respectfully ask you to give the floor to Professor Grzebek.
I thank Mr. Klaga. I now give the floor to Professor Patrycja Grzebek.
Mr. President, members of the Court, it is an honor to appear before you to discuss legal obligations of states to allow humanitarian assistance in armed conflicts. Those obligations are not dependent on an assessment of which party to a conflict started the current phase of hostilities, or a determination of who is the aggressor and who is exercising the right of self-defense. IHL must be blind to such considerations if it is supposed to work at all. The question asked by the General Assembly refers to the obligations of an occupying power. This is why some written statements have focused on assessing...
Excuse me to interrupt you, but please speak more slowly. Thank you very much.
Whether Israel is occupying the Gaza Strip, a problem addressed by the Court in 2024 opinion. In that opinion, the Court stated that Israel's obligations under the law of occupation have remained commensurate with the degree of its effective control over the Gaza Strip. It is undisputed that on 19 December 2024, when the GA requested another advisory opinion, Israel had a certain degree of effective control over the Gaza Strip. To that extent, it also had obligations as an occupying power. Nevertheless, Poland wishes to recall that GA also asked the Court to assess Israel's obligations as a member of the UN. In Poland's opinion, Article 2, Paragraph 2 of the UN Charter is of particular relevance here, as this provision emphasizes that all UN members shall fulfill in good faith the obligations assumed by them. Referring to that principle, GA Resolution 2625 indicated that every state has the duty to fulfill in good faith its obligations under the generally recognized principles and rules of international law. In consequence, every UN member is obliged to respect its treaty and customary obligations concerning humanitarian assistance, no matter whether it is considered as an occupying or a non-occupying power in a particular armed conflict. In case of an armed conflict, each party bears a primary obligation to meet the basic needs of the population under its control and to prevent starvation. Humanitarian organizations may always offer assistance, but their ability to act is dependent on the consent of the party that controls a given territory. It must be, however, noted that in a situation of occupation, if all or part of the population of an occupied territory is inadequately supplied, Article 59 of the Fourth Geneva Convention clearly stresses that the occupying power shall agree to relief schemes on behalf of the state population and shall facilitate them by all the means at its disposal. Therefore, in cases of occupation, cooperation with other states and impartial humanitarian organizations is not a choice, but an obligation. Poland also wishes to draw attention to Article 23 of the Fourth Geneva Convention, which indicates that in all situations, states are required to allow the free passage of all consignments of medical and hospital stores intended solely for civilians and the free passage of all consignments of essential foodstuffs, clothing and tonics intended for children under 15, expectant mothers and maternity cases. This obligation must also be respected when a state decides on siege warfare, whose purpose cannot be the starvation of civilian population. When civilians do not have the opportunity to leave a besieged area, a duty arises to supply them with relief goods. Every state has a right to defend itself and to take all necessary security measures. However, those measures must comply with international law. ICJ gives the right to inspect, to regulate times and routes, and to supervise distribution of goods. However, states cannot lawfully prevent the provision of humanitarian assistance by humanitarian actors if the most basic needs of the civilian populations are not satisfied. Humanitarian assistance, when provided to the civilian population in a non-discriminatory, impartial manner without any adverse distinction, cannot be suspended by the arbitrary withdrawal of consent to the operation of humanitarian organizations and by the denial of humanitarian workers access to the civilian population. This arbitrariness definitely appears when the denial of humanitarian assistance means that civilians may starve. Because Israel controls Palestinian borders, it also controls access to assistance and thus decides whether civilian population lives or dies. It should be stressed that international community doesn't condone treating a civilian population as an enemy. With the adoption of the 1949 Geneva Conventions, it had already abandoned the paradigm of total war. Humanitarian assistance, by its very nature, must be delivered promptly, often within days or hours. The situation where people die because at the border food is rotting, medicine expiring, and vital medical equipment stuck cannot be accepted. It cannot be understood why life-saving medical equipment, including ventilators for neonatal intensive care units, portable incubators for newborns, and other
Madam, please speak more slowly, please.
And other aid supplies are stored at the border. Poland is convinced that there is a legal obligation to lift any blockade placed on life-saving aid. Poland also wishes to note that humanitarian obligations are not based on reciprocity. The exclusion of reciprocity is stressed in the very first Article 1 of the Geneva Conventions, where states specifically undertake to respect and ensure respect for the conventions in all circumstances. States must fulfill their obligations without regard to whether other belligerents apply the Geneva Conventions. As an additional guarantee of non-reciprocal respect for ICJ, Article 8 of the Fourth Geneva Convention states that protected persons cannot renounce their rights in part or in entirety. There is also a clear prohibition on reprisals against protected persons and objects expressed in every Geneva Convention and in the first additional protocol, as well as prohibition of collective punishments. In addition, Article 50, paragraph 1, letter C of the Articles on Responsibility of States for International Wrongful Acts prohibits the application of countermeasures that would affect obligations of humanitarian character. Some states expressed doubts about whether ICJ refers to obligations towards third states, the United Nations, or other international organizations. However, Article 59 of the Fourth Geneva Convention obliges an occupying power to cooperate with third states and impartial humanitarian organizations on relief schemes. Also, this court, in judgment of 1986 in Nicaragua versus USA case, stated that there can be no doubt that the provision of strictly humanitarian aid to persons or forces in another country, whatever their political affiliations or objectives, cannot be regarded as unlawful intervention or as in any other way contrary to international law. Israel has expressed doubts concerning the role of UNRWA. However, not only UNRWA, but all UN agencies and humanitarian organizations were forbidden to operate in Gaza Strip. The provision of humanitarian assistance in crises, such as the one we are observing in the Palestinian territories, require coordination, in which the UN Office for the Coordination of Humanitarian Affairs plays a crucial role. The cluster approach to humanitarian assistance, whereby various UN agencies and organizations take the lead role in particular sectors of humanitarian assistance, is the only solution that reduces duplication of effort and ensures the reliable delivery of aid prioritized by needs. Therefore, cooperation of states with the UN is essential to protect civilians, properly address their needs, and avoid wasting finite resources in a world where needs seems to be infinite. Poland duly noted in some written statements submitted in these proceedings, references were made to neutrality as an essential requirement for humanitarian organizations to be allowed to provide assistance. In this respect, we are of the view that certain opinions conflated neutrality with impartiality, even though these two notions are clearly distinct. This court, in 1986 judgment in Nicaragua versus USA case, explained the specific nature of impartiality when it stressed that an essential feature of truly humanitarian aid is that it is given without discrimination of any kind. It must be given without discrimination to all in need. Poland would like to kindly notice that Articles 13, 59 of the Fourth Geneva Convention, as well as Articles 17 and 18, respectively, of the First and Second Additional Protocol, in their references to humanitarian aid, require only that such assistance aim to alleviate suffering and be provided impartially. Neutrality means that humanitarian actors should not take sides in hostilities. Poland agrees that neutrality helps to ensure integrity of the organization's mission and the effectiveness of its operations. Still, the alleged lack of neutrality based on vague accusations cannot be used as an excuse for prohibiting humanitarian actors from delivering assistance to the population in need. Mr. President, members of the Court, I now turn to the issue of protection of humanitarian workers and relief goods. Humanitarian workers, including medical personnel who provide humanitarian assistance during armed conflicts, are not targets. They must be respected, which means they cannot be attacked. They must also be protected, which requires states to prevent others, including their own citizens, from interfering with aid workers' ability to do their jobs. Those rules are expressed in every Geneva Convention and its additional protocols. Humanitarian workers assisting the civilian population are not helping the enemy. They are saving humanity in inhumane circumstances. Civilian humanitarian workers lose protection only when they take direct part in hostilities. This loss of protection, however, is strictly temporary and applies only to the time of harmful engagement. Having in mind the presumption of civilian status expressed in Article 50, paragraph 1 of the first additional protocol, which in Poland's opinion is an expression of customary law, any killings of humanitarian workers needs to be thoroughly investigated. States are not left alone with this task. There are many tools at the disposal of the belligerent states to clarify the circumstances of humanitarian workers. Deaths, including the International Humanitarian Fact-Finding Commission, which states can ask to investigate incidents. Even non-parties to a conflict may request help from the Commission, as Poland did in the case of Polish humanitarian worker killed in Gaza. If a state responsibility is confirmed, then it must comply with accountability requirements and ensure reparations. Civilian goods classified as humanitarian assistance should be respected in accordance with the principle of distinction. This category concerns such basic goods as food, water, medicine, clothing, bedding, means of shelter, and other goods necessary for the survival of the civilian population. Poland is concerned about the practice of classifying medical equipment or water, sanitation and hygiene equipment as dual-use goods, which could allow them to be withheld from the civilian population or their supply to be limited. Poland understands why fuel or gas might be classified as dual-use, but at the same time the role such raw materials play in sustaining civilian infrastructure, like hospitals, cannot be ignored. Mr. President, would you allow me to prolong my statement for 2 minutes just?
Yes.
While assistance provided in a non-impartial manner cannot be classified as humanitarian, this doesn't mean that such consignments can be automatically targeted as military objectives. They may still be entitled to broader protection given to civilian objects under ICJ. Medical units enjoy even greater special protection, which on the one hand means an obligation not to use them for military purposes, and on the other introduces additional requirements including appropriate warnings that must be met before such units may be lawfully attacked if they are really used to commit, outside their humanitarian duties, acts harmful to the enemy. Modern international humanitarian law began by extending protection to the sick and injured, as well as to medical personnel and units. It is unimaginable that these basic rules are still violated, and we forget that hospitals should be respected as sanctuaries in times of war. In this regard, it is necessary to uphold the obligation to respect and protect humanitarian workers and relief goods, as well as the obligation to investigate all incidents of attacks against humanitarian workers or goods. This concludes Poland's oral pleadings. Thank you for your kind attention.
I thank the representatives of Poland for their presentation. Before I invite the next delegation to take the floor, the court will observe a break of 15 minutes. The hearing is suspended. I now invite the next participating delegation, Qatar, to address the court. And I call His Excellency Dr. Multak Al-Qadani to the podium. You have the floor, sir.
Mr. President, honorable members of the court, it's a great honor and a privilege to appear before you today as the representative of the State of Qatar in these important proceedings. Mr. President, the court's advisory opinion of 19 July 2024 confirmed that Israel's presence in the occupied Palestinian territory is unlawful and must be brought to an end as rapidly as possible. Unfortunately, Israel did not end its occupation. It has continued its genocidal war against the Palestinian people, especially in Gaza, which is not only an international crime, but the crime of crimes which shocks the conscience of mankind. It's a blatant disregard of the court's advisory opinion, and in a blatant disregard of the court's advisory opinion, Israel increased settlement and annexation in the West Bank through force. According to the UN, approximately 1,000 Palestinians have been killed there since October 2023, and over 40,000 have been forcibly displaced by settler violence and Israel's military campaign in the West Bank. As the UN Special Rapporteur and the OBT stated in a press release that you can find at tab 1 of your folders, we're witnessing new trails of tears in the West Bank, mirroring Gaza's fate. In Gaza, Palestinians also continue to face famine-like conditions as Israel has completely blocked any delivery of life-saving aid of millions of Palestinians. In a joint statement on April 7th, top UN officials stated that more than 2.1 million people are trapped, bombed, and starved again in Gaza, and that Israel's acts of war show an utter disregard for human life. You can find this statement at tab 2 of your folders. At the same time, Israel has jeopardized the very existence of UNRWA, the backbone of humanitarian and development assistance across the OBT. This renders these proceedings of a paramount importance. Qatar, and I'm certain all other participants, are grateful to the court for the efficient conduct of these proceedings. Mr. President, members of the court, the rest of my intervention will be divided into two parts. First, I'll explain how Israel has created and perpetuated, in violation of its international obligations, a humanitarian disaster in Gaza. Second, I will set forth Qatar's positions on Israel's campaign to dismantle UNRWA in violation of its international obligations. But before turning to these issues, allow me to briefly address the scope of the questions put to the court. The General Assembly has not asked the court to merely list Israel's obligations in the abstract. Rather, it has asked the court to identify concretely Israel's specific obligations in relation to its conduct in the OBT. As Qatar explained in detail in its written statement, this is implicit in the preamble of the General Assembly's resolutions. For example, the court is being asked to assess, inter alia, whether Israel's legislations banning UNRWA is compatible with Israel's international obligations. Moreover, Qatar agrees with the State of Palestine that it would be artificial to separate the primary obligations from secondary obligations that arise directly out of Israel's violations. Israel's relevant obligation can thus be understood as encompassing also Israel's obligations arising from state responsibility, such as obligation of cessations and reparations. For example, as Qatar has explained in the case of the illegal legislations banning UNRWA, Israel has an obligation of cessation and must repeal the legislations immediately. Mr. President, members of the court, I will now turn to my first topic and explain how Israel has created and perpetuated a humanitarian disaster in Gaza in violations of its international obligations. Since the outset of its onslaught in Gaza, Israel has consistently used the abbreviation of humanitarian aid and basic utilities as a method of war. Qatar will not address all Israel's crimes in Gaza. I will only focus on two categories relevant to the questions before the court. First, humanitarian aid, including food and water, and second, healthcare. As to the first category, at the beginning of the war, Israeli leaders announced a complete siege on Gaza, allowing no electricity, food, water, or fuel to enter. Since then, Israel has systematically prevented the delivery of life-saving aid by humanitarian organizations, in particular by UNRWA. Israel blocked humanitarian crossings in Rafah, Karam Abu Salim, and northern Gaza. In November 2024, UNRWA reported that Israel allowed entry of an average of only 30 trucks of humanitarian aid per day. This is only about 6% of the daily amount of aid that entered before the war. As a result of the mediation of Qatar alongside Egypt and the United States, Israel eased these restrictions when the latest ceasefire agreement came into force. The delivery of humanitarian aid scaled up during that brief period. However, this small progress was completely reversed on 2nd March 2025, the second day of the holy month of Ramadan, when Israel decided to cut off entry of all food, water, and other supplies in Gaza. As a group of UN independent experts explained, Israel is weaponizing humanitarian aid. You can find their press release at tab 3 of your folders. Indeed, Israel is using aid as a tool of extortion to further its military goals and as an act of collective punishment. In addition to blocking the distribution of aid, Israel has systematically targeted water infrastructure, food storage facilities, and aid convoys. Israeli military strikes have killed both national and international humanitarian personnel, as well as Palestinian civilians receiving aid. As a result, according to OCHA, hundreds of thousands of people are facing a catastrophic levels of food insecurity. Civilians, in particular children, have died of starvation and lack of potable water. Under our collective watch, Mr. President, it's an entire generation of Palestinians that Israel is destroying. Israel's conduct related to humanitarian aid has violated numerous international obligations. Qatar will only name a few relevant obligations that should not escape the court's attention. First, Qatar agrees with the State of Palestine, the United Nations, and other participants that as an illegal occupier, Israel has no standing to determine what states or international organizations are given access to Gaza. This is a prerogative of the Palestinian people in accordance with its right to self-determination. As the court has repeatedly held, Israel, as an occupying power, has the obligation not to impede the Palestinian people from exercising its right to self-determination. Second, as highlighted by almost all participants, international humanitarian law imposes both positive and negative obligations on Israel as an occupier. Not only must Israel refrain from blocking aid under Articles 30, 23, 52, and 61 of the Fourth Geneva Convention, but must also actively facilitate the entry and rapid distribution of humanitarian aid under Articles 23 and 61 and protect relief supplies against looting. Moreover, Israel has an obligation under international humanitarian law to both respect and actively protect humanitarian personnel and facilities. Third, Israel has an obligation not to use the starvation of civilians as a method of warfare by depriving them of objects indispensable to their survival. This includes willfully impeding relief supplies. Starvation is a war crime and the serious violations of international humanitarian law codified under Article 8 of the Rome Statute. Crucially, in November 2024, the pre-trial chamber of the International Criminal Court found that there were reasonable grounds to believe that the war crime of starvation has been committed. The pre-trial chamber's confidential decision is summarized in the press release included in tab 4 of your folders. Since March 2025, starvation is once again officially Israel's policy. It is thus urgently necessary for the court to recall Israel's obligations to put an end to this illegal policy. Fourth, in the South Africa versus Israel, the court has ordered Israel to take all necessary and effective measures to ensure, without delay and full cooperation with the United Nations, the unhindered provisions at a scale of urgently needed basic services and humanitarian assistance. Qatar, along with at least 21 other participants, have pointed out to the applicability of the court's binding provisional measures orders issued in South Africa versus Israel case. Israel's failure to respect these orders is an added indication that it's in fact committing acts of genocide. Fifth, Qatar agrees with the 24 participants that have insisted on the application of the Convention of the Rights of the Child, to which Israel is a party. Under Article 6, Paragraph 2 of that convention, which reflects customary international law, state parties shall ensure to the maximum extent possible the survival and the development of the child. Israel is thus under unequivocal obligations to ensure the adequate nutrition of children and their survival. Respectfully, Qatar calls upon the court to emphasize the jus cogens character of this obligation. I now turn to healthcare. Mr. President, Israel has left Gaza's system medical care on the brink of the total collapse. Israel has blocked the entry into Gaza of healthcare workers, basic medicines, anesthesia, and life-saving equipment. At the same time, Israel has blocked and delayed safe evacuations by international organizations and 30 states of patients from Gaza, including children waiting cancer treatment. This atrocity has occurred in the context of Israel's widespread and systematic attacks against hospitals. In particular, UNRWA health centers have been targeted, with less than a third still functioning in Gaza, according to OCHA. Israel has also targeted hospitals established or supported by 30 states, including the only hospital specialized in cancer treatment. As a result, more than 1,400 medical professionals have been killed, and many have been arbitrarily arrested and tortured, according to the Office of the High Commissioner for Human Rights. This includes the 15 paramedics and aid workers discovered in a mass grave on 30th March 2025. More information about this incident can be found at tab 5 of your folders. Mr. President, this conduct is a flagrant violation of Israel's obligations under international law. Under international humanitarian law, Israel has the duty to respect and protect medical facilities, staff, and transport, notably under Articles 18, 20, 21, and 22 of the Fourth Geneva Convention. This means that it must refrain from targeting them. Israel must also, under Article 56 of the Fourth Geneva Convention, ensure that hospital and medical services can properly work and that medical personnel of all categories are allowed to carry out their duties. Mr. President, members of the Court, I will now turn to my second and final topic, namely Israel's unlawful campaign against the United Nations, in particular UNRWA. Israel has long seen the UN as a thorn in the side of its colonial project in Gaza. The presence of the UN and the OBT promotes the self-determination and social cohesion of the Palestinian people by enabling them to enjoy certain very basic economic, social, and cultural rights. This is particularly true of UNRWA, which under normal conditions operate schools, health clinics, refugees camps, and provides food, shelter, and other social services to about 5.9 million Palestinian refugees in the OBT. It is thus not surprising that Israel has repeatedly attempted to thwart UNRWA's operations. Israel has a documented history of conducting intentional military strikes against UNRWA's property and staff during its previous attacks against Gaza Strip. As explained in detail by the State of Palestine on Monday, Israel has also called for the defunding of UNRWA on numerous occasions in multilateral fora, even before October 2023. Recently, Israel even used commercial billboards around the world and paid Google ads to spread misinformation about UNRWA, painting it as a terrorist organization and calling for its dismantlement. As the United Nations explained, concern about the UN must be brought to the attention of the organization so that the matter may be considered by the United Nations in accordance with its legal framework, including the privileges and immunities of the organizations and its personnel. Under this framework, the United Nations has the exclusive prerogative to decide when privileges and immunities is to apply. As the Court is aware, the independent review order by the UN Secretary General concluded that UNRWA has a more developed approach to neutrality than similar UN entities or NGOs. However, this did not deter Israel, which maintains its offensive against UNRWA. On the 28th of October 2024, Israel passed legislation which inter alia prohibits all contacts between Israeli authorities and UNRWA and prohibits UNRWA from operating any representation, providing any services, or carrying out any activities, directly or indirectly, within the sovereign territory of the State of Israel, which Israel legally considers as including East Jerusalem. You can find the text of this legislation at tab 6 of your folders. When the law came into effect at the end of January 2025, as you can see from Israel's letter at tab 7 of your folders, Israel required UNRWA to cease its operations and evacuate all its premises in East Jerusalem with less than 1 week's notice. This led to the evacuation of international staff from UNRWA's East Jerusalem offices to Jordan, while local staff were encouraged to stay home for their safety in light of arson attacks and violent protest. Israel has stated its intention to seize UNRWA's facilities in East Jerusalem and turn them into yet another illegal Israeli settlement. In parallel, Israeli forces have detained UNRWA staff members, including while on official duty. According to a March 2024 UNRWA report, UNRWA staff were held incommunicado and subjected to ill treatment and torture to obtain forced confessions. And in line with Israel's conduct during past hostilities in Gaza, since October 2024, Israeli forces have destroyed or damaged 2/3 of UNRWA's facilities and killed at least 290 UNRWA staff members, including in the line of duty. Israel conduct toward UNRWA bluntly violates its international obligations. And while Qatar's statement focuses on UNRWA, the same applies to Israel's conduct toward other United Nations bodies and specialized agencies targeted by Israel, such as the World Food Programme and World Health Organization. As most participants have pointed out, Israel has no unilateral right to determine how the UN organizes itself in the OBT and has an obligation to allow it to continue to operate through UNRWA. This primarily stems from Article 2, Paragraph 5 of the UN Charter, which provides that as a UN member, Israel must give every assistance in any action the UN takes in accordance with the Charter. The General Assembly established UNRWA in accordance with the Charter. Thus, Israel has no obligations to second-guess that mandate or impose conditions on its exercise. Rather, it must cooperate with UNRWA and facilitate its operations. Moreover, as a UN agency, UNRWA, its property and personnel enjoy privileges and immunities, notably under Article 105 of the UN Charter, under the 1946 General Conventions on the Privileges and Immunities of the United Nations, and under customary international law. These privileges and immunities pledge Israel to allow UNRWA to fully function in Israel and in the OBT. These legal protections cannot be abrogated unilaterally by Israel. Therefore, even if UNRWA could be replaced, which it cannot, Israel has no right to demand that it be replaced. Israel's legislation substantially hinders UNRWA's operations throughout the OBT because it prohibits any contact between any Israeli authorities and UNRWA's or its representatives. This in turn could preclude Israeli authorities from providing UNRWA employees the permits that they require to even enter the OBT and from coordinating the passage of aid into the OBT. This reason alone is sufficient for the court to find that Israel is under an obligation to immediately revoke and cease to implement its 28 October 2024 legislations. As explained, the illegality of this legislation is at the heart of the General Assembly's request. Qatar thus respectfully asks the court to make an explicit finding in this regard. Mr. President, I will make 4 additional brief points regarding UN's privileges and immunities in the OBT. First, as the UN Legal Council stated under Section 3 of the General Convention, Israel has an absolute and mandatory obligation to respect the inviolability of United Nations premises, property, and assets at all times, including during armed conflict. They therefore cannot be expropriated, confiscated, bombed, or otherwise intervened with. Instead, the UN property and personnel must be protected at all times, including from private actors. Second, the UN and its officials enjoy a right of access to the OBT. As stated, Israel's occupation is illegal, and Israel has no standing to obstruct entry of the UN into the OBT. Moreover, both Article 105, Paragraph 2 of the UN Charter and the General Convention require Israel to ensure the freedom of movement of UN officials, including the Secretary General, and of experts on mission, such as Special Rapporteur. Third, Israel's detention of UN personnel for words spoken or acts done in the exercise of their function violates their immunity from legal process guaranteed under Section 18 of the General Convention. Israel's arbitrary detention of UNRWA personnel infringes at least on the United Nations' right to visit and communicate with detained staff members. Fourth, Qatar, like 19 other participants and the UN itself, emphasizes that the UN privileges and immunities cannot be overridden by military necessity or security or considerations of security. This is because they arise directly from the UN Charter and thus prevail over all international obligations in accordance with Article 103 of the Charter. This has been the United Nations' consistent position. Mr. President, in conclusion, Qatar is of the view that Israel has flagrantly violated its obligations under international law in relation to the presence and activities of the UN, other international organizations, and third states in and in relation to the OBT. This includes its obligation to respect international organizations' privileges and immunities, its obligations under the UN Charter to cooperate with the UN, its obligations under international humanitarian law, and its obligation to respect the Palestinians' rights to self-determination. As a result, Israel is under an obligation to seize these violations, to provide full reparation for the damage caused by them, and to provide guarantees and assurances of non-repetition. Finally, although the scope of this advisory opinion is limited to Israel's own obligations, Qatar would like to recall that all states have an obligation not to render aid to Israel and its violations of these obligations to the extent that they impede the Palestinian people's right to self-determination. Mr. President, honorable members of the court, this concludes my submissions on behalf of the State of Qatar. Qatar is grateful to all states and international organizations that have presented their views on the urgent questions posed by the General Assembly. Qatar remains deeply appreciative of the Court's sustained attention to these critical matters and of its unwavering commitment to the maintenance of international peace and security and the enforcement of international law, particularly for those populations whose rights and protections are under the greatest threat. Let us be guided always by the enduring principle that salus populi suprema lex esto, the welfare of the people shall be the supreme law. Thank you, Mr. President. Thank you, honorable members of the court, for your kind attention.
I thank the representative of Qatar for his presentation. I now invite the next participating delegation, the United Kingdom, to address the court, and I call upon Ms. Sally Langrish to take the floor.
Mr. President, members of the court, it is an honour for me to appear before you in these proceedings and to do so on behalf of the Kingdom, the United Kingdom of Great Britain and Northern Ireland. The United Kingdom welcomes this opportunity to emphasise its support for the role of the Court, for the United Nations and for international law. Let me reaffirm at the outset the United Kingdom's condemnation of Hamas for their outrageous actions on the 7th of October 2023 and their ongoing threats to Israel. Their hostages have endured and continue to endure unimaginable cruelty. We call for the immediate and unconditional release of all hostages. The United Kingdom has consistently urged Israel to ensure access to humanitarian assistance in accordance with its international obligations. In a speech on the 20th of March 2025, the Foreign Secretary made it clear that the United Kingdom was resolute in calling on Israel to abide by international law and to lift the unacceptable restrictions on aid and demand the protection of civilians. The UK's announcement of the suspension of arms export licences on the 2nd of September 2024 was underpinned by the clear risk that certain military exports to Israel might be used in violation of international humanitarian law, an assessment that was based in part on Israel's restrictions on the provision of humanitarian assistance. On Tuesday this week, the Foreign Office Minister of State addressed the UN Security Council. He called for a return to the ceasefire to end the relentless death and destruction that Palestinians face daily. He stated, and I quote, "It is unacceptable that Israel has blocked humanitarian support from entering Gaza for nearly 2 months, meaning that Palestinian civilians, including 1 million children, are facing starvation, disease and death. UN and other workers must be able to deliver life-saving assistance safely and in line with humanitarian principles. Mr. President, Israel must facilitate full, rapid, safe and unhindered humanitarian provision to the population of Gaza, including food, water and electricity, and must ensure access to medical care in accordance with international humanitarian law." The United Kingdom voted in favour of Resolution 79232 in line with its strong commitment to international rule of law. Our vote in no way detracts from the United Kingdom's commitment to Israel's security or its commitment to negotiations between the two parties towards a two-state solution. Only the achievement of that goal will put an end to the continuing humanitarian tragedy. Mr. President, members of the Court, the United Kingdom is of the view that the Court has jurisdiction and that there are no compelling reasons not to give an opinion. We wish, however, to stress the importance of the principle that a state is not obliged to allow its disputes to be submitted to judicial settlement without its consent. We urge the Court, as it has often done, to reaffirm that principle of consent. Having said that, rendering the present advisory opinion would not, given the terms of the question focusing on obligations, circumvent that principle. This is particularly so since the United Nations has a direct and special interest in this case. Mr. President, I would request that you now invite Sir Michael Wood to the podium to address certain questions of United Nations law, and then following Sir Michael, I shall return. Thank you, Mr. President.
I thank Ms. Langrish. I now invite Sir Michael Wood to address the Court. You have the floor.
Mr. President, members of the Court, it's an honour to address you and to do so on behalf of the United Kingdom. I shall first say a few words about the question before the Court. I shall then address the obligations of Israel as a member of the United Nations. I make 4 points about the question. First, the question asks about the obligations of Israel as an occupying power and as a member of the United Nations. While it does not ask about the obligations of any other actor, the question is framed in general terms, and at least in some respects, the Court's response is likely to be relevant to the obligations of all members of the United Nations and to the obligations of all occupying powers. Second, the question is limited to the obligations of Israel. It does not expressly ask about the rights of Israel, in particular its right of self-defense. But any answer must have regard to Israel's rights. In addition, and as noted by the Secretary-General, the focus of the question on the obligations of Israel does not prejudice in any way the obligations of other relevant actors such as Hamas. Third, the question does not ask about violations. It has been suggested by a number of speakers that the court should address questions of state responsibility. But in our submission, to do so would distort the question for which states, including the United Kingdom, voted. Fourth, the question covers a wide range of United Nations bodies, as was well explained in the Secretary-General's written statement. Mr. President, members of the Court, I now turn to the obligations of members of the United Nations under various provisions of the Charter, in particular Articles 104 and 105, as well as the obligations under the 1946 General Convention on the Privileges and Immunities of the United Nations. On Monday, the Distinguished Legal Counsel of the United Nations set out the position with great authority. Mr. President, members of the Court, we agree with the UN Legal Council on the importance of states fully respecting their obligations concerning the legal capacity, privileges and immunities of the United Nations, so as to enable the organs of the United Nations to fulfill their mandates. Compliance in good faith with Articles 104 and 105 of the Charter and the General Convention is of the greatest importance for the effective functioning of the United Nations throughout the world. Before turning to some of the obligations of UN member states under the Charter and Convention, I must mention the obligation of the United Nations to cooperate with the host state. Section 21 of the General Convention provides that, and I quote, "The United Nations shall cooperate at all times with the appropriate authorities of members to facilitate the proper administration of justice, secure the observance of police regulations, and prevent the occurrence of any abuse in connection with the privileges, immunities, and facilities mentioned in this article." In this context, it's important also to recall Article 100 of the Charter, which states that United Nations staff shall not seek or receive instructions from any government or from any authority external to the organization, and they shall refrain from any action which might reflect upon their position as international officials responsible only to the organization. As others have said, under the General Convention, the United Nations enjoys immunity from every form of legal process, immunity for its property, and perhaps most importantly for present purposes, its premises are inviolable. UN officials are immune from legal process in respect of words spoken or written and all acts performed by them in their official capacity. As stated on behalf of the Secretary-General, the privileges and immunities owed to the United Nations are applicable to UNRWA, a subsidiary organ of the General Assembly, and must be respected at all times. Mr. President, members of the Court, I now turn to Article 2, Paragraph 5 of the Charter, to which a number of participants have referred. It is not clear that, in the present context, this very general provision adds anything to the more specific obligations applicable to Israel as an occupying power and as a member of the United Nations. It may not be necessary on the present occasion for the Court to delve into the questions that have been raised concerning the scope of Article 2, Paragraph 5. The cooperation at issue in the present case is more easily covered by other provisions of the Charter and IHL. If the Court were, however, to find it necessary to refer to Article 2.5, it may wish to exercise some caution. This, I think, seems to have been the approach of the UN Legal Council on Monday. I should recall that on the relatively rare occasions when Article 2.5 has been invoked, this has usually been in very general terms. As early as 1949, in the Reparation for Injuries advisory opinion, the court considered the need of protection for agents of the organization, and in that particular context, stressed the importance of the duty to render the organization every assistance. As you are aware, members of the court, Article 2.5 has two limbs which are closely related. Under the first, all member states are required to give the United Nations every assistance in any action that the United Nations takes in accordance with the Charter. Under the second, all members are required to refrain from giving assistance to any state against which the United Nations is taking preventive or enforcement action. Should the court consider it necessary to address Article 2.5, the United Kingdom's position is that the first limb applies only to action taken by the Security Council. If Article 2.5 were to provide for an obligation to render every assistance to any action in a wider sense, that would impose unspecified and potentially unlimited obligations on members. It would call into question the carefully defined system of competences of the principal organs as laid down in the Charter. The court has heard from some participants the view that even recommendations adopted by UN organs are binding on member states, and towards the implementation of which they must give every assistance. That view, in our submission, is unrealistic and does not reflect practice. The rare past references to Article 2.5 do not suggest that the General Assembly can impose obligations on members where none existed. Only decisions of the Security Council can do that. The word action, as opposed to cooperation, is employed in the Charter with particular reference to action by or authorized by decisions of the Security Council. This can be seen, for example, in Articles 11.2 and 24, and in Chapter 7, which is entitled Action with Respect to Threats to the Peace, Breaches of the Peace, and Acts of Aggression. While the General Assembly can make recommendations to member states, only the Security Council is given a power to impose an explicit obligation of compliance, as the court noted in the Certain Expenses opinion. The drafting history of Article 2.5 supports this view. The Dumbarton Oaks proposals contained two separate paragraphs, which were combined at San Francisco without discussion. That suggests that they cover similar ground. Indeed, at San Francisco, one delegate stressed that the first limb of Article 2.5 should be understood to refer to action taken by the Security Council, as this was the only organ of the organization having authority to take action. That statement was not challenged by any delegation. This interpretation is supported by the virtually uniform and consistent practice of the United Nations and member states with respect to UN missions and staff. The latest edition of the Zimmer Commentary on the Charter, after an extensive evaluation, concludes that the practice, and I quote, supports the narrow interpretation which conceives the obligation to give assistance to apply only for enforcement measures under Chapter 7 of the Charter. End of quotation. Mr. President, members of the Court, to be clear, the obligations of Israel as a member of the United Nations, of course, have to be read together with its obligations as an occupying power throughout the occupied Palestinian territories. And with that, Mr. President, I request that you invite Ms. Langrish back to the podium to discuss that matter. I thank you, Mr. President.
I thank Sir Michael Wood. I now give the floor back to Ms. Sally Langrish.
Mr. President, members of the Court, I shall now address you on Israel's obligations under international humanitarian law as an occupying power. You have ample material before you on international humanitarian law, so I can be relatively brief. I shall conclude my statement by referring to the obligations owed to the International Committee of the Red Cross, a matter to which the United Kingdom attaches great importance and which we suggest could be reflected in your advisory opinion. As is stated in Article 43 of the 1907 Hague Regulations, under the law of occupation, Israel, as the occupying power, shall take all the measures in his power to restore and ensure as far as possible public order and safety, l'ordre et la vie publique. This fundamental principle reflects customary international law and is elaborated on in the provisions of Geneva Convention, GC 4 of 1949. Two provisions of GC4 are particularly relevant. Articles 59 and 55. I will address these in turn. Under Article 59 of GC4, Israel is bound to facilitate the provision of foodstuff, medical supplies and clothing into the occupied Palestinian territories. A number of points bear emphasis. First, Article 59 provides that if the whole or the part of the population of an occupied territory is inadequately supplied, the occupying power shall agree to and facilitate relief schemes on behalf of the population. Once this obligation is triggered, the occupying power is required to agree to relief schemes on behalf of the said population. That obligation continues to apply for so long as part of the population is inadequately supplied. A refusal to negotiate or agree to relief schemes will constitute a violation of Article 59. Second, the occupying power must facilitate relief schemes by all means at its disposal. This obligation is unconditional. Facilitation requires wholehearted cooperation in the rapid and scrupulous execution of these schemes. This includes the provision of transport, storage and distribution facilities. Third, relief schemes may be undertaken either by states or by impartial humanitarian organisations. In circumstances where the civilian population of the occupied Palestinian territory is inadequately supplied, Israel may not withhold consent to offers to conduct humanitarian relief operations that are exclusively humanitarian and impartial in nature. The United Kingdom considers that UNRWA is an impartial humanitarian organisation for the purposes of Article 59 of GC4. Insofar as impartiality is understood as meaning neutrality, UNRWA also satisfies that requirement. The Colonna report states that, I quote, since 2017, UNRWA has established and updated a significant number of policies, mechanisms and procedures to ensure compliance with the obligation to uphold the principle of neutrality, end of quote. The United Kingdom has made clear its serious concern about the two recent Knesset laws. We have reiterated our support for UNRWA's mandate to provide essential services and humanitarian assistance to Palestine refugees in the occupied Palestinian territories. At the same time, the United Kingdom has been clear that UNRWA should abide by the highest standards of neutrality and that any allegations otherwise should be independently investigated. The United Kingdom notes that UNRWA has adopted a high-level action plan to respond to the Colonna report's recommendations. So far, UNRWA has fully implemented 5 recommendations, including sharing staff lists with Israel and providing for a centralised neutrality investigations unit with international staff. The United Kingdom supports UNRWA's continued work and commitment to the principle of neutrality in line with the Colonna report. Any alleged involvement of UNRWA staff in the barbaric terrorist attacks of 7th of October 2023 and subsequent allegations must be thoroughly investigated. The United Kingdom expressed its deep concern in respect of Emily Damari, a UK national who was taken hostage on the 7th of October, and about reports that she was held in an UNRWA facility. The United Kingdom welcomed the UNRWA Commissioner General's call for an independent investigation into any reported misuse of UN premises by Palestinian militants including Hamas. Overall, an occupying power retains a discretion in principle as to which states or organisations provide assistance. However, in circumstances where 1. The occupying power is unable to meet the needs of the population, 2. No other offer of assistance will be sufficient to render adequate assistance, and 3. The humanitarian need is grave and urgent, it would be incompatible with a good faith performance of Article 59 to refuse an offer of assistance from an organisation that has capacity. Such refusal would be incompatible with the obligation to use all means at its disposal to facilitate relief schemes on behalf of the population. Mr. President, I turn now to Article 55 of GC4. Pursuant to Article 55, an occupying power has a duty to ensure the food and medical supplies of the population to the fullest extent of the means available to it. Where the resources of the occupied territory are inadequate, the occupying power comes under an additional obligation, in particular, to bring in the necessary foodstuffs, medical stores and other articles. This extends to bringing in supplies necessary for an adequate standard of living, including clothing, bedding and shelter. Article 55 does not prescribe the method of compliance. What is essential is that the occupying power takes measures to ensure the necessary food and medical supplies for the population. This requires the occupying power to maintain at a reasonable level the material conditions under which the population of the occupied territory lives. It is open to an occupying power to procure the supply of food and medical supplies through a third party, including through a relief scheme under Article 59. In a situation where an occupying power decides to meet its obligations through a third party, such as UNRWA, the occupying power must ensure the safety and security of that third party as far as possible. In circumstances where an occupying power has failed to ensure the food and medical supplies of the population, a failure to agree to and facilitate relief being provided by that impartial organisation is likely to constitute a violation of both Article 59 and Article 55. This conclusion is reinforced by two obligations which both inform the content of Articles 59 and 55 and also constitute independent obligations. First, Israel is under an obligation under customary international law to allow and facilitate rapid and unimpeded passage of humanitarian relief for civilians in need.
Excuse me to interrupt. Could you please speak slowly? Thank you.
Forgive me, Mr. President. Second, Article 55 requires an occupying power to allow protecting power to verify the state of food and medical supplies in occupied territories. That obligation can only be temporarily restricted for imperative military reasons. Restrictions are, moreover, only authorised as an exceptional measure and may not, at any time, be of a general or permanent nature. Finally, it should be recalled that Article 60 makes clear that the fact that humanitarian agencies are providing services and assistance to the population does not relieve the occupying power of any of its responsibilities under Articles 55, 56 and 59. Mr. President, members of the Court, as a concluding point, it is important to highlight the International Committee of the Red Cross. The ICRC plays a vital role in protecting the lives and dignity of victims of armed conflict, providing assistance and promoting respect for international humanitarian law. As members of the Court are well aware, the law of occupation provides a special position for the ICRC that shall be recognised and respected at all times. With respect to visits to protected persons, this is spelt out in detail in Article 143 of GC4. Under Article 30 of GC4, protected persons shall have every facility for making application to the International Committee of the Red Cross. The right to be visited by the ICRC equally applies to protected persons charged with offences by the occupying power. Visits to detainees by the ICRC may not be prohibited, except for reasons of imperative military necessity, and then only as an exceptional or temporary measure. The exception is expressed in narrow terms. The provision applies equally to the hostages being held in Gaza. Mr. President, there have been repeated credible reports of ill treatment of Palestinian detainees held in Israeli custody since the 7th of October attacks. ICRC visits and access to those interned at times of conflict is aimed precisely at ensuring that they are treated humanely and with dignity, and to provide some information to their families and loved ones as to their well-being. It should be noted that neither the ICRC nor anyone else has been able to visit and access the Israeli and other hostages being held in Gaza by Hamas and other militants. Hostages released have shared horrific stories of ill treatment and abuse that may amount to torture. This also is completely unacceptable, but cannot serve as justification for Israel to deny the ICRC access to Palestinian detainees since October 2023. Mr. President, members of the Court, in our statement today, we have aimed to assist the Court by indicating our views on the question put to the Court and on the obligations of Israel, both as a member of the United Nations and as an occupying power. Mr. President, members of the Court, that concludes our oral statement in these proceedings, and we thank you for your attention.
I thank the representatives of the United Kingdom for their presentation. This concludes this afternoon's sitting. The oral proceedings will resume tomorrow at 10 a.m. in order for China, Senegal, Slovenia, Sudan, Switzerland, and the Comoros to be heard on the questions submitted to the Court. The sitting is closed.